During a visa interview, an applicant mentioned having a sibling in the US, thinking it showed family support. However, the consular officer saw it as weak ties to their home country and refused the visa under Section 214B despite the applicant's admission to a top US business school. Determined, they reapplied, emphasizing strong ties like property ownership and a job offer back home, and their visa was approved. If you or someone you know has been denied a visa under 214B, it can feel confusing or discouraging. Let's break down what it means and how you can overcome it. Let us start by saying this type of denial is common and it does not mean you can never get a visa. It simply means that during your interview, the consular officer wasn't convinced that you met all the requirements for the non-immigrant visa category you applied for. Let us explain. Under US immigration law, all applicants for non-immigrant visa except certain categories like H-1B and L visas are presumed to have intent to immigrate permanently to the United States. To qualify for your visa, it's your responsibility to overcome this presumption by demonstrating that you intend to return to your home country after your temporary stay. So, what does this mean in practice? It means you need to show strong ties to your home country. Ties are the various aspects of your life that connect you to where you live, things that make it clear you plan to return home. These ties can be different for everyone, depending on their personal circumstances. For example, strong ties might include a stable job that requires your return, owning property like a home or business, close family relationships like taking care of children, parents, or a spouse, other obligations or commitments that make leaving permanently unlikely. During your interview, the consular officer considers your overall situation, your travel plans, financial resources, and the ties you present to decide if you qualify for a visa. If the officer feels your ties aren't strong enough or that your plans aren't clear, they are required by law to refuse the visa under Section 214B. Now, let's address an important question. Is a 214B denial permanent? The answer is no. This type of refusal applies only to the specific application you submitted, and there is no appeal process for the decision. Once the case is closed, the consulate can't take any further action. However, this doesn't mean you can't reapply. If you believe there's new information the consular officer didn't have during your first interview, or if your circumstances have changed significantly since your last application, you can submit a new application. When you reapply, you will need to complete a new form, pay the application fee again, and schedule a new interview. Make sure you are prepared to address the concerns raised during your previous interviews and provide an additional evidence to strengthen your case. Here's our advice for anyone reapplying after a 214B refusal. First, take some time and think about your ties to your home country. Are there aspects of your life, your job, your family, your property that you did not highlight in your first application? If so, be ready to share those details during your next interview. Second, be honest and clear about your travel plans. Consular officers are looking for applicants who can explain their reasons for visiting the US, whether it's for tourism, education, or business, and who can show they will return home afterward. Finally, don't be discouraged by a 214B refusal. Many people reapply successfully after addressing the concerns raised in their initial application. The key is to be well prepared and provide as much evidence as possible to demonstrate your eligibility. Thanks for listening and good luck with your application journey. Remember, we are here to help you every step of the way. Take care.